If the judge does not terminate the parental rights, the FG case is closed and the FN docket is reopened. And at that point, a new permanency plan needs to be developed. Prior to their rights being terminated, parents may voluntarily surrender their parental rights. There are two kinds of surrender: general surrender and identified surrender. In general surrenders, parents just choose to surrender their rights to their child, and no conditions are put on that surrender. The parents are not specifying who will adopt the child, and in that surrender, the parent is going to acknowledge their rights are being terminated, and they are relinquishing custody of the child. In an identified surrender, parents surrender the rights to a specific person as the adoptive parent. So basically, the parent is saying, I am going to terminate my parental rights as long as my sister or my brother or this person is the one who gets to adopt my child. If for some reason that parent fails to adopt the child, then the parental rights are reinstated. Many times, the voluntary identified surrender is facilitated for remediation. It's arranged for a parent to go into a meeting with the division and the caretaker or whoever else might be involved to see if they could work out an agreement which might result in the voluntary identified surrender. So we've been talking about the termination of parental rights, whether it be through a trial or surrender of those rights. And the reason why we need to terminate a parent's rights, one way or the other, is so that a child can be adopted. Adoption can only happen after a parent's rights have been terminated or surrendered. And at that point, the child is now legally free for adoption. If the parent's rights were terminated as a part of a trial, the parent does have a right to an appeal. Then an adoption cannot be finalized because the appeal is pending. Once the child is adopted, the FC case that has remained open this whole time is at this point closed. In some cases, rather than adoption, kinship legal guardianship may be more appropriate. While the name kinship applies that it involves a relative, that is not actually the case. There does not have to be any special biological relationship for a caretaker to become a legal guardian. In these cases, parental rights are not terminated, and they retain some rights when it comes to the children. Folks who do KLG have to be okay with the fact that the parent may still be in the children's lives in some capacity, including possibly visiting the children. When the division files paperwork for a KLG, the case is given an FL docket number. Many times, relatives do prefer doing KLG because they want the parents to have the opportunity to continue to be in the children's lives, and they might feel awkward legally becoming mom or dad by adopting the children. KLG is another agreement that can sometimes be worked out through mediation, where all of the parties sit down together, and KLG is the strategy that makes the most sense for a permanency plan in this particular case. Whoever the caretaker is of the children has to actually agree to KLG and understand that parents may still be part of the child's lives. Sometimes caretakers are adamant about not wanting KLG and wanting to adopt a child because they do not want that lingering relationship. I just wanted to finish up by talking a little bit more about AFSFA, the Adoption and Safe Families Act, which, as we talked about, is a federal law that requires child welfare institutions like the Division to seek termination of parental rights when a child has been in placement for 15 of the most recent 22 months. As I mentioned earlier, ASFA can be complicated and there are exceptions to the rule. Unless one of the exceptions are met, the Division does have to file the termination. The exceptions include 1. If the child is being cared for by a relative. 2. The Division has documented a compelling reason why termination of parental rights would not be in the child's best interests. Or 3. The Division has not provided to the children's families the services necessary for the child's safe return home. So if any of these 3 exceptions are met, the Division does not need to seek termination of parental rights, and alternate permanency plans besides adoption can be followed. As I said in the beginning, I know this presentation covered a lot of information and details, and we do not expect you to memorize all of this information or be able to recall anything off the tip of your tongue if you were asked. We do want you to have this as a guideline to help you understand the progress of your case, what's coming up on your case, or what may have happened previously on your case. Most importantly, this is intended to make you feel more comfortable as you get started working on your cases. And of course, your supervisor is always going to be there to answer your questions and help you figure out what's actually going on.